cops often do as they wish, forgetting that they are not above the law. Today, we'll be going through these cases where corrupt police officers were instantly owned and humbled in courtrooms. Officer Michael Wagner had arrested defendant Lisette Gonzalez for a DU1. However, during court proceeding, it was revealed that he never administered a breathalyzer test, yet falsely recorded that she tested above the legal limit. When the judge learned of this, he responded in a way that had not been seen in courts before.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to null process that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point...
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
This action visibly angered the judge, and he would not stop here as he went on to grant more favors to the defendant.
This whole case was fishy, and I have no idea how they... You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
You don't agree with the state's decision on
I'm
the
granting the
other
JOA
charges?
in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion, the JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? Appeal me.
Thank you, Your Honor.
The case should have never been done. Never.
Thank you for letting us know that, Your Honor.
The judge not only reversed his decision, but acquitted the defendant on the spot, leaving the arresting officer and his attorney in dismay. Well, sometimes police officers do the unthinkable in courtrooms, costing their cities thousands of dollars. In a September 2012 hearing of an assault case, Judge Doris Bird laid out punishment for an assault Anthony Waller when a police officer decided to take matters into his own hands.
Investigation for false imprisonment, assault in the third degree, assault as a class 2 felony, and a misdemeanor charge as well in possession of drug paraphernalia.
I'd like to object first. If I'm under investigation, I thought the investigation came first, then the rest came. Hold on, man.
Get on your feet. You don't turn on me. Get on your feet.
Waller was only talking to the judge when Deputy Brady Lovingier slammed him to the ground before taking him away. The suspect later claimed that he suffered broken teeth and head wounds. As a result, the deputy was suspended by the sheriff's office and ultimately resigned. On the other hand, Mr. Waller ended up getting $50,000 in damages from a federal jury. This officer lost his job for this. But what happened to this next bully in court will leave you all satisfied.
5 individuals claimed that this defendant taped them when they were not consenting to it, when they were not looking.
January 2023, Behar County Deputy Andrew Garcia was arrested for using his taser on cadets in training. Garcia was charged with 2 counts of official oppression, assault with bodily injury, and harassment. He pled guilty to the charges as Judge Boyd proceeded with the case.
You entered a plea to account for tampering with the government record. You entered a plea of guilty. The state waives counts 1, 2, 3, 5, 6, and 7. According to the plea bargaining agreement, punishment is to be assessed at 1 year in the state jail facility. The state recommends community supervision. They're opposing your application for deferred adjudication. Have both parties had a chance to review the PSI report, state?
Yes, Judge. We have.
Defense?
Yes, Your Honor. In fact, I've gone over my client and given him a chance to read at his own pace.
It was Deputy Chavez.
No. Not in training, because you were not tasing people in training. I know that sometimes, and I don't know if it's still the case, I think it's not the case, they would tase officers in training so they would know This is the voltage of the taser. This is how it feels.
The state attorney explained what Deputy Garcia had actually done. The revelations will surely leave you in shock and dismay.
Yes, Judge. So this defendant took advantage of people who he was supposed to be supervising and training in the Bexar County Jail. He was the CERT deputy in charge of cadets and lockdown units with violent offenders, people with ag assaults, murder charges pending. At least 5 individuals claimed that this defendant tased them when they were not consenting to it, when they were not looking, and that he did it in front of inmates, which, jeopardizes the security of the jail and also does not help with the retention issues that the jail is having as well. At least 2 of the victims left after that they were tased because they didn't want to be part of that work environment. Some of them were tased on the arms, legs, back, stomach. Multiple people said they did not want to be tased. He did it anyways. There's evidence that after he tased them and that the victims would ask him, "Why'd you do that?" He would look at them and smile. Some of the people consented to being tased. However, it was under a type of duress. For example, one of the victims went to him asking for clippers so that they could cut the inmate's hair in another unit. And he said, "I'll give them to you if you let me tase you."
It's bizarre to hear that a law enforcement officer was being a straight-up bully and was harassing his juniors who were there for training. However, the events keep on getting worse.
In the PSI, I noticed that he said that he had been tased before. There's evidence that was uncovered throughout the investigation that he would, when the victims would say, "Hey man, why'd you do that to me? Have you ever been tased?" He would respond back with, "No, and I'm not going to let anyone tase me." So I don't know which part of that is actually true. Judge, I just want to make it very clear that when these reports come out and when all this stuff is happening, they don't say Andrew Garcia was tasing people in the jail. They say a Bexar County Sheriff's deputy was tasing people. He's besmirched the badge of the Bexar County Sheriff's Office. This is supposed to be a controlled environment, and he added chaos to an already chaotic environment. By doing this in front of the inmates, it put not only him in jeopardy and the cadets, but also the other inmates. And it is his sole job in the jail to maintain the health and safety of the inmates who are there. When he was confronted about it, he put on a government record that he does not recall this ever happening. However, in the PSI, he says the reason he did it is because it was done to him. The old saying, if all your friends jump off of a bridge, are you going to do it too? And here it seems like he just went along with it and was tasing all these cadets.
The poor cadet who was multiple times spoke to investigators, or else this unlawful practice might have continued even longer.
The defendant is 6'10", 245 pounds, at least at the time when he was working there. One of the victims is 5'2" and 112 pounds. And he reported that he was held up against the wall physically, and that this defendant would not set him down, that he would put him into an arm bar in front of other inmates and tase him multiple times in front of other inmates. This was not a one-off time, Judge. If it was, I don't think the state would be having such an issue with the bird. It's the fact that we found out that this happened to 1, 2, 3, 4, 5, 6 individuals. And the one individual he didn't tase, he would harass. So when he would go to start doing his checks on the inmates, this defendant would point the red dot at him, come up behind him and clack the taser while the cadet was just trying to do his job. Therefore, the state thinks that this defendant should carry a conviction because of the egregiousness and because he has besmirched the badge of the Bexar County Sheriff's Office.
Defense.
It seemed the bully enjoyed harassing and attacking those innocent young cadets. Shortly after, his attorney had the floor, and the corrupt deputy tried his best to play the victim card.
What you're accused of by tasing and harassing these cadets is not a proper work environment or training environment for them.
100%.
Okay. Have you learned from this not to do something like that?
100%, yes.
Okay. Were you ever tased? Yes or no?
Yes, I was.
Okay. And is it part of training that everybody's going to get tased sooner or later? Normally a time when they get tased.
At a time and a place, yes.
Okay. And did you notice anything from the inmates reacting to your alleged misconduct?
I'm saying I do not recall tasing in front of inmates.
Okay. All right. So, and this is your first offense,
Yes, sir.
correct?
Okay.
Okay.
Excuse me. Norma.
This is a first-time offender. I do understand what I did was, wrong. I would not do it again. It was a mistake. I'm about to get married here in the next couple of weeks. I asked for, if you could on deferred, I would greatly appreciate it. Have them a lesson, Your Honor. And I would never ever do anything like this again.
Any questions?
Any questions from the state?
Just a few questions. So your attorney asked you, you know that that's not a proper work environment, stuff to do in the work environment, correct? But you understand this is more than just some type of workplace harassment, that was criminal conduct you were doing?
Yes.
Where you were housing people who have allegedly committed crimes?
Correct.
So in fact, you were committing crimes in the jail?
Correct.
No further questions, Judge.
Nothing else, John.
All right.
After the defense and state presented their arguments, Judge Boyd took charge and announced the sentence. But before that, she took this bully to the cleaners.
We are actually going to marriage license to pick up the proper documents, and then whenever I guess they have their scheduling, we'll pick a date, but as soon as possible.
All right. The state is asking for you to have a conviction. If this were counts 1, 2, 3, 5, 6, and 7, I would probably have no question about giving you a conviction. But however, you do need to be punished. And punished is not just permanent surrender of your TCO license. So I'm going to give you a choice. I will give you 4 years deferred adjudication. With that, you're going into custody to the Bexar County Jail for 30 days. That's your punishment. Or I will give you a conviction. Which do you choose?
And the conviction, are you just giving regular probation? Is that what you're saying,
Yes.
Your Honor?
Deputy Garcia was a lying coward. The only reason he didn't want to go to the same jail he worked at was because he couldn't face the cadets he was bullying for fun.
Only one that works within my family. My wife is focused on her degree, and it's. I don't want to be in jail, Your Honor.
Well, the people you tased, they just wanted to, I'm assuming they were there to support their families as well. So why were you tasing people? And I don't want to hear, because how old are you?
24.
24. I don't want to hear this is like college and people are hazing people. I never understood why people who had been hazed decide to haze other people. So why were you tasing people at the jail who are just there? And I know those cadets are young because I've seen some of them. They're 18. Some of them look as though they're 12. So why were you tasing cadets?
Your Honor, doesn't make it right. It's a thing that's going around.
Oh, you're saying there are other cadets there are other people at the name.
Deputy Garcia tried to cover up by claiming it was a long-standing practice. The judge cut him off and went over to humble him for the next few minutes, leaving him speechless.
Who are tasing people at the jail.
Off the top of my head, Your Honor, it's been a while. I don't.
No, I'm thinking, who tased you? Give me a name. I'm sure the state would like to know these names. So who are the names of the people who were tasing you?
Your Honor, I do not remember.
Of course, you always remember the first person who tased you.
The first person who tased me was in proper training.
Oh, what's their name?
That was.
All of the complainants in this case remember you as tasing them. That's why you're here. So who tased you?
In proper training, it was Deputy Chavez.
No. Not in training, because you were not tasing people in training. I know that sometimes, and I don't know if it's still the case, I think it's not the case, they would tase officers in training so they would know this is the voltage of the taser, this is how it feels. Much like in the military, when they release the gas, so you'll know how to wear your mask properly. No, I'm talking about who tased you improperly, because that's why we're here. You're saying people hazed you, so you're just hazing people. So who are these people who tased you when you were not in training?
Your Honor, I do not remember names.
All right, so who else is tasing people at the jail?
Garcia tried to dodge the question, but didn't realize he was up against a brilliant judge who wouldn't let him off so easily.
Because that's what you're telling people. You're telling me, you're telling the states, you're telling the attorney that there's tasing happening at the jail. I'm sure those cadets don't want to be tased if it's not in training. So who are these other people who are tasing cadets? We want to know. So tell me who they are. Do you need to sit in the box while you think of the names of the people?
Mr. Randall.
Any reason why you're Are you not intentionally not remembering names, correct?
No, I cannot remember.
Oh, I mean, if you want to sit in the box and think about the names, because you can't just throw around people are being tased at the jail by other people and then that's it. Who are these people who are tasing people? There's nothing worse. Well, there may be other things that are worse than people who say, well, I heard. But you're not saying I heard.
Yes, ma'am.
You're saying, oh, now you're changing it to I heard?
I haven't seen someone get tased. I've heard of stories of people getting tased, and I just ran with that.
Oh, so he's never seen anybody tased. So now he's not just continuing the hazing that happened to him. He was just tasing people. Your unborn child, is this going to be a girl or a boy?
He's born 4 months old. He's a boy, yes, ma'am.
The deputy continued making a joke of himself, left with no answers. The pathetic bully never considered his actions wrong, and the judge kept pressing on his vague excuses.
He's born 4 months old. He's a boy, yes, ma'am.
4 months old. So what if he decides to be a cadet at the jail and somebody like you, who's 6'10", however much you weigh, is tasing him?
I would be unhappy with that.
Mm-hmm. How unhappy would you be?
Very unhappy. Very unhappy.
And how would you think the work environment would be for your son when they're constantly worried about some guy who's bigger than them tase them?
As a parent, I would not approve of that work environment, Your Honor.
Mm-hmm. That's what you did. Some people would call it being a bully, but that's what you did.
Yes, ma'am.
So you deserve a conviction, and I'm going to give you a conviction. Is there anything else from either party? In the state jail facility, suspended and probated for 4 years. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting. Oh, and if I haven't said it before, I'm finding you guilty. There's to be regular reporting by Zoom or in person. There's to be regular UAs. There's to be the permanent surrender of your TCOL license. And I know sometimes people will give up their TCOL license, but then they go to another state and they're allowed to become officers again. So while you're on this probation, there's to be no employment as a security officer.
In my opinion, the deputy was lucky not to get a jail sentence. His punishment felt like a slap on the wrist. But the judge made sure to humble him one last time.
Court is not waiving any of those hours, and I'm going to require parenting classes. Probation, is there anything else? Is there anything else you need from the court to be successful?
Want the judge give you anything, help you at all? This is your time to ask.
Sir, is there anything else you need from the court to be successful on this probation?
No, no.
All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, we can go off the record. I understand why you don't want to do your time at the Bexar County Jail. And you know what? I know it has to do with people in the box and security for you at the Bexar County Jail. So that heavy beating of your heart, that's the heavy beating that all of those cadets had whenever you were on shift. And you need to remember that. Do you understand?
Sure.
All right, good luck to you. Yes.
I apologize for field visits.
Yes, field visits once a month for 3 months. All right, just have a seat. They'll go over conditions with you. With your attorney, did you understand it and did you sign it? All right, we can go off the record. I understand why you don't want to do your time at the Bexar County Jail. And you know what? I know it has to do with people in the box and security for you at the Bexar County Jail. So that heavy beating of your heart, that's the heavy beating that all of those cadets had whenever you were on shift. And you need to remember that. Do you understand?
Sure.
All right, good luck to you. Yes.
I apologize for you want field visits.
Yes.
Garcia was immediately fired from the Behar County Sheriff's Office. And although he wasn't arrested, he will never get to be a law enforcement officer again, thanks to Judge Boyd. Well, this isn't the last time a judge destroyed an officer in court, as this case will leave you stunned.
At least give me the satisfaction of knowing that you're out there beating up niggas. LOL. How humiliating and degrading. Be a positive example to Officer Zelenuski.
On January 28, 2015, Inkster police officer William Mendez and his partner John pulled over a black man for a traffic violation. What followed will shock you as Judge Vonda Evans details the incident during the trial.
I'm going to start out with Mr. Dent. The victim involved in this tragedy is a 58-year-old black man who was driving his Cadillac in Inkster, a suburb of Detroit. On the evening of January 28, 2015, where his life changed forever, he was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zelenuski. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and struck 16 times in the head by the defendant. In his attempt to arrest him, he was thrown onto a window shield of a patrol car, bleeding profusely from a head injury. The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten and cuffed.
This horrible beating had left Dent's face and shirt drenched in blood, but the officer's reaction to this was even worse.
The video in the car shows the police officers fist bumping as a celebratory act of bravery by the defendant and his cohorts. But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head. In disbelief of what had occurred to him. If his conduct was indicative of what he was thinking, I would have thought this: what crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers looking at. As police officer John Zelenuski, auxiliary police officer, testified in court too, in his response to a text, was quoted as saying, "At least give me the satisfaction of knowing that you're out there beating up right now. LOL. How humiliating and degrading that must have been."
After his arrest, the officers kept on humiliating, cleaned his blood off their uniforms with disinfectant. Dent was also charged with resisting arrest and the judge was devastated by the events and delivered a powerful, heartfelt lecture.
He was left in a cell for a number of hours before getting medical treatment. But after hearing the defendant and his fellow officers joke about his injuries as they were wiping blood off their uniforms with disinfectant. 2015. Please be quiet in my courtroom. How does this happen? I'm going to tell you how it happened. Some years ago, 19 to be, well, 25 to be exact, I remember coming into this building with such enthusiasm, so excited. And I remember a lawyer telling me that nobody leaves out of this building like they came in. I didn't understand what that meant. You go to social events, you tell people what you do for a living, and after they say, what kind of cases do you hear? And as a judge, prosecution, defense, does criminal defense, a police officer, after a while they say, we don't want to know anymore. That's the job in the criminal justice system.
Racist Officer William could only sit and listen as the judge spoke. How fitting that he was being humbled by an African-American woman.
These pressures and expectations force officers who have a pure desire to purely serve the community as an occupation to conform to this group mentally or face being ostracized and labeled as an outcast among that group. These methods of indoctrination are passed along to new police recruits in the academy by stressing the importance of obedience to authority through a structure of shame and honor. It teaches them to conform and obey to the prevailing standards of the police culture. Field training, the recruit gets a reality check of what it's like to be out in the city. I was out at a mall yesterday. I asked a woman a question. I said, you don't have to answer. How much do you get paid an hour? She said, $15 with benefits. Well, guess what? That's more than what Inkster gets. They don't get benefits. The equipment, the police cars are old. We went out to the scene. Early in the morning, there were people who were using drugs. They just kind of came out. And the only thing I could imagine was the only thing that is separating these people from drugs are the police officers that appeared in my court.
Judge Vonda not only blasted the officer in question, but also questioned the overall system that produces such cops. On the other hand, all charges against Dent were dropped, and he settled with the city for $1.4 million.
According to Law Enforcement Today, a publication, police officers had the highest rate of alcoholism, divorce, drug abuse, suicide. Their life expectancy is 10 years less than the average American. Police are human beings too. They feel despair and they have ups and downs. Their job is made worse because they see on a daily basis, more than any other occupation, the worst behavior that people can inflict on one another. They go to work every day with the knowledge that some of the people that they are sworn to protect and serve want to kill them. But how do we as a community expect superior services from police officers who are making security guard salaries to receiving little compensation and struggling just to pay health care? We would rather save a few dollars to balance a budget than pay millions of dollars to reverse a tragedy that we could have prevented. I know that Mr. Dent would give back every dime of his $1 million settlement to go back to where he was in his life before January 28th. I wonder what would one half of that $1.4 million settlement awarded to Mr. Dent have done for the Inkster Police Department. Training officers that wanted to serve and not hiring officers that didn't belong. It's my belief that when we begin to value and properly compensate and train those that want to serve, then and only then will we as a community receive the type of services that we expect and demand from the defenders of our community, the police. It's amazing how poor cities like Flint can find millions of dollars to attempt to reverse a situation that $100 a day could and would have prevented.
Moving on, we have this insane cop who was taken to the cleaners by this vigilant judge. Officer Eric DeValcanaire and his partner responded to a call about a person chasing his girlfriend in his pickup truck. Eventually, the suspect decided to head back home, and as he was entering his driveway, Officer Eric asked him to step outside. When the suspect didn't comply and remained in the truck, DeValcanaire twice on the spot. He was charged with and after a lengthy trial, the judge finally delivered a verdict.
Parties have a right to expect that no matter what I hear, I will only consider factors that are appropriate and that I will disregard those that are inappropriate. And that is what I've done here, and as a result, I've concluded as follows. There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead. And Eric DeValkenaer, that's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel.
Judge Dale Youngs understood the entire case and lectured the corrupt cop before announcing his verdict.
Cameron Lamb's death leaves an irreparable and unfillable void in the lives of his family and his friends, and also in our community. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Schwam and the defendant. Pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a, "Hey Troy, wait." At any point, Sergeant Schwam and the defendant could have done this.
The victim, Cameron Lamb, was not even reaching for a gun when the cop shot him. The judge narrated the events as the tyrant listened in agony.
A fact that is made even more aggravating as the court considers an appropriate sentence in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage. Then Sergeant Schwam and Eric DeValkenaer arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor.
This sad incident stems from the fact that these corrupt cops overestimate their authority. The tyrants wandered inside his house without any warrant and ended up poor guy inside his own home.
The circumstances of the offense as described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValkenaer, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house. Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction. I know that. and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things.
The judge was rightly tearing apart the corrupt cop, but just as he neared his conviction, he started to gather some sympathy for the racist officer.
Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him.
It was disheartening to see the judge side with the suspect, especially since this case appeared to be a clear-cut murder, much like the ones mentioned earlier.
Cameron Lamb is dead. Eric DeValconaire killed him. And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
Time from the state.
No, sir.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
This officer learned his lesson, but this next cop was caught planting on people and owned in the courtroom.
It appears to be an illegal narcotic. Do you know anything about that?
I do not. No, what is that?
I'm just trying to figure out how that stuff got in your car. You gonna go to jail today for possession of method?
Oh man, dude, I'm serious, dude. Anything, what you want me to do, man? And I knew my truck was clean. I knew it was.
Anything in the vehicle I need to be concerned about? Bombs, hand grenades, rocket launchers. Okay.
It is yogurt, sir.
I know. Okay.
It's yogurt.
How about this, though?
That is not mine. No, sir.
Okay.
Now, the white small plastic baggie that was in that spoon that the deputy just showed you on this video, had you ever seen that before?
No, sir.
Was that in your car?
No, sir.
The court proceeding mostly consisted of evidence as all the 12 drivers testified against Zachary. Finally, the jury reached a verdict and it was announced.
In the state of Florida versus Zachary Tyler Wester, case number 19-CF-431. We, the jury, find as follows as to the counts charged and the information. Count 1, guilty of racketeering as charged. Count 2, not guilty. Count 3, not guilty. Count 4, not guilty. Count 5, not guilty. Count 41, guilty of possession of controlled substance related to February 15, 2018 as charged. Count 42, not guilty. Count 43, not guilty. Count 44, guilty of possession of a controlled substance related to April 17, 2018 as charged. 65, guilty of false imprisonment related to Stephen Van as charged. Count 66, not guilty. Count 67, not guilty.
All right, Mr. Clerk, if you'll go ahead and poll our jury. Ladies and gentlemen, I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in your jury room.
The verdict was read as all the 67 charges were read individually, and Zachary was found guilty of 19 of them, including racketeering, official misconduct, and possession of controlled substances. In a final hearing, the judge announced his sentence.
Mr. Wester, this court now sentences you as follows in this case. As to count 1, racketeering, which is a first-degree felony, you are sentenced to serve 5 years in the Florida Department of Corrections. As to count 7, official misconduct, as a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That will be served concurrent with count 1. As to count 65, false imprisonment, as a third-degree felony, you are sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 64. Counts 7, 9, 10, 31, 33, 34, 41, 44, 48, 64, and 65 are to be served consecutive to each other for a total sentence in this case of 12 years, 6 months, and 8 days in the Florida Department of Corrections. This sentence of 12 years, 6 months, and 8 days in the Florida Department of Corrections is to run concurrent with a 5-year Department of Corrections sentence in count 1. Therefore, it is the intention of the court that you are sentenced to serve a total of 12 years, 6 months, and 8 days in the Florida Department of Corrections. I'm also going to award the defendant 58 days jail credit as to count 1 and count 7.
The corrupt deputy was rightfully sentenced to 12.5 years in prison. Well, this officer was definitely corrupt, but the actions of this next cop were so hideous, he was given the ultimate sentence.
The court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270.
The tragic death of George Floyd at the hands of Officer Derek Chauvin on May 25, 2020, sparked a worldwide movement calling for justice and police reform. Chauvin was charged and eventually convicted of second-degree unintentional murder, third-degree murder, and second-degree manslaughter.
I wanted to thank everybody for being here and for providing the input you did. Not just the people who were in the courtroom here, but also those who provided written statements, both from the Floyd family and the defendant's family. I've read all the impact statements that were submitted earlier and listened carefully to all the input here today. And it is truly appreciated that you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law, but my comments are actually going to be very brief. Most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case.
Derek stood still and refused to show any emotions that would display guilt and remorse. The police officer knew he was about to face a long sentence.
What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever because it's not the appropriate time. I'm not basing my sentence also on public opinion. I'm not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases.
The judge made it abundantly clear that the sentence would not be based on public uproar and emotions, but would be decided strictly according to the law. That's when he announced the sentence.
Mr. Chauvin, as to count 1, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentence for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis.
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything from the defense? No, Your Honor. All right. Thank you. We are adjourned.
Well, that brings us to the end of this video. Today, we saw police officers getting owned in courtrooms after committing terrible acts while on duty. These cases serve as a powerful reminder that no one is above the law. No matter who you are, you will be held accountable if you break it. If you agree with me, please consider showing your support by liking this video. And also make sure to subscribe to stay informed about future cases like these. Also, if you enjoyed this video, check out the next video here.